So let's do your budget and your debt. The first thing to do is make a list of your debt. This time you should have a credit report. You can get one right now for free at www.annualcreditreport.com. This is the only website where you can get a free credit report. Other websites only give you one for free if you sign up for their services, like credit monitoring, at a monthly cost. Then you need the credit list. You may already have a list of your debts prepared. If you don't, click on the button, Print Form Creditor List button now, and start on it with me. You need a budget. You can print the budget form and fill in your expenses and your income on the budget form on this website, or you can fill in the information below and then print a budget based upon IRS standards. The information to fill in on the website is your residence zip code, how many people are in the household unit, and what's the yearly gross household income. If you live in a household where you share income and expenses, include all the income. Now, I'm going to discuss the different types of debt that most people face in the order of importance according to the U.S. Bankruptcy Code. One serious mistake people make is dealing with only part of their debt. Don't think that making arrangements with a couple credit cards while failing to deal with others will solve your problem. You should take all debt into consideration because you have to use your income to pay all debt to avoid collection problems. The first debt we'll discuss is domestic support obligations, or DSOs. Bankruptcy Code defines a DSO as a debt in the nature of support, maintenance, or alimony owed to a spouse or ex-spouse or child or such child's parent or the legal guardian or responsible relative or a governmental unit. And this debt is established or subject to establishment in a separation agreement, divorce agreement, property settlement agreement, or other court order. It doesn't have to actually be a court order, but it has to be this type of debt. It's basically any debt in the nature of support. They cannot be affected by credit counseling. You must pay DSOs, or you can lose a professional license or driver's license. You can lose a nursing license for not paying your DSOs. These DSOs are not dischargeable in bankruptcy. Now, a property settlement that doesn't involve support, such as an agreement to pay bills, is not a DSO if both parties are self-supporting and there's no child support or other support issues. However, if you make such an agreement, a property settlement to pay bills in a divorce, it is not dischargeable in Chapter 7, but may be partially discharged in a Chapter 13. So, if you're in the process or thinking about it, don't make agreements to pay marital debts if you can't stick to them. It may be better to do a bankruptcy or joint bankruptcy before divorce to eliminate that as an issue. Past due DSO can be paid in a Chapter 13 over time. So if you have support arrears, as long as you can start making current obligations that have to be paid in the future, you're okay. Chapter 7 has no effect on DSOs, neither does any other kind of debt settlement or negation scheme or agreement outside of a court order or a Chapter 13 plan. Often, Chapter 7 can eliminate most debts so you can concentrate on paying your support. You should list each payee for each DSO if you have more than one separately. If you're behind, put the amount next to the DSO payee and list the current monthly payment amount in your budget. List the payment for arrears under the court order in your budget. Give a copy of the court order, marital settlement agreement, or other DSO papers to your attorney. Second type of debt that's most important is tax debt. If you have past due tax debt and can't pay your bills because you withhold too much, so you get a big refund, you're not helping your problem. Gather your last 4 years' IRS and state returns if you can. Of course, if you didn't have to file, you don't. Make copies, not originals, since your attorney or counselor will want to see them, and get any IRS notices in order along with the returns. A licensed attorney with tax training can eliminate or repay taxes in a bankruptcy. Generally, taxes due within 3 years of filing a bankruptcy have to be paid, as well as taxes where you didn't file a return. But if you filed a tax return and the taxes were due over 3 years ago, and you filed the return on time or late more than 2 years ago, and more than 270 days have been passed after the assessment, you may be able to discharge that tax liability in bankruptcy. There are so many complicated rules that apply to taxes. Don't try this at home. If you fail to file a return, requested an extension, the IRS filed for you, if you file late, you haven't been assessed, etc., you need a law firm with tax experience to represent you in a bankruptcy. For non-bankruptcy tax payment and negotiation, you can go directly to the IRS yourself or have an enrolled agent who's qualified to represent you. Do not go to tax schemers that are fly-by-nights. Credit counseling will not help with tax debts. If you owe taxes and own real estate, you should check the grantor-grantee index at your local county recorder of deeds. Many of these are online to see if a tax lien has been recorded against you and your property. There are other benefits to bankruptcy if you have tax debt, including the ability to pay it ahead of other creditors, pay it without interest, agree with the IRS to take less, and deal with tax liens. Tax liens don't go away unless you have paid the entire liability and they attach to property, both real and personal, that you acquire after the lien filing and after bankruptcy, and they last for 10 years. So it's very important to deal with tax debt if you want a true fresh start. The third category is debt secured by real estate. These debts include first mortgage, only secured by real estate that's your personal residence. Junior liens on real estate, like home equity loans, are called HELOCs, home equity line of credit. C, real estate taxes, water and sewer bills, they're secured by real estate by local law. Judgment liens. A judgment lien can become a lien on your real estate when entered against you by a judge or when the judgment is recorded. Tax liens and other liens, such as mechanics liens, or condominium or homeowner's assessment. If you have any of the above debts, list them on your creditor list. Second, if you want to keep the property, A, on your creditor list, list any past due payments to the creditor as a separate debt. And on your budget, put the regular payment in your budget form. Number 3, if you're filing a bankruptcy, copy your closing packet for your attorney, who will want to see who's on title and who signed the mortgage and note. If you're keeping the property, copy your insurance declaration for your attorney and put a monthly amount for insurance in your budget if it's not included in your mortgage payment. Put your mortgage payments in your budget, as well as any insurance that you pay on the house. Copy your real estate tax bill. It's available online or at your county assessor's office, and if it's not included in your monthly payment, divide it by the number of months in a year and put it in the budget. D, if it's a condominium or homeowners association, if it's due, list it as a creditor if behind, and put an amount in for future assessments in the budget. If you're not keeping the property, put an amount in your budget for rent. Do not abandon the property. Live in it until sheriff's sale. If it's a condo or homeowners association, after bankruptcy, pay your condo assessments until it's sold. Bankruptcy does not eliminate future condo or homeowner associations on property you still own or other debts after the bankruptcy is filed. It eliminates personal liability on pre-filing assessments and debts, but the assessments are still secured by the property. And of course, any debt incurred after filing, like a homeowner or condo assessment relating to the property, is yours, so keep it insured. Whether you want to keep your real estate or not, whether it's your residence or not, you're generally going to have to maintain it until you sell it or a sheriff's sale sells it. Do not abandon it because it's still yours. You can be sued if someone's hurt in it, and debts arising from it after the bankruptcy may still be yours. So stay in the property and maintain it until someone else takes it off your hands. In many cases, you can live in it for free for a year or two while foreclosure processes continue. In some cases, banks won't even foreclose, and you can save money to buy it back if it is foreclosed, while you live there for free if no order to pay rent is entered against you. Chapter 7 provides no relief for payment of secured liens. Chapter 13 does. Be afraid, very afraid, of relying on bogus schemes, debt negotiators, fly-by-night brokers or debt managers or modification schemes. They just don't work and you will lose money. Get face-to-face advice, not on the internet, from a real licensed attorney in a real law firm, not someone associated with some company with some bizarre trade name where you don't even know who's really involved. Go to a Chapter 13 attorney if you want to save your home. That's what your budget is for, to plan how to pay debts you need to pay. There is almost no way to manage DSOs, tax debt, or secured debt through any third party. Credit counseling is not set up to deal with these debts, and anything you try outside of bankruptcy is liable to be a fraud scheme. Number 4, debts for vehicles. If you have a payment on a vehicle, whether it's for a lease or purchase, put the payment in your budget, unless you're just a cosigner and aren't making the payment. If you don't want the vehicle, don't put a payment in the budget. Put the monthly payment for car insurance in the budget. Divide a 6-month premium by 6 for your monthly payment. You must have full coverage, not just liability if you have a financed vehicle. List the loan or the lease for a vehicle on your creditor list. If you're a cosigner, check the box and list the cosigner's name. If you have a loan with a credit union and have other debts like a credit card, list these under the vehicle loan as separate debts, but check that they are also secured by the vehicle, because they usually are. List the date you purchased the vehicle in the box provided. If you don't want the vehicle, mark it surrender. If you do, mark it reaffirm. If you're behind, mark the behind box and put in the last paid date. Now, if your vehicle has been repossessed recently and not sold, Chapter 13 filing may return the vehicle to you. You can get the vehicle back yourself by paying the past due and repo charges directly. No private service can force return of a vehicle, and most will not negotiate a lower payment. If you have a repossession deficiency after the vehicle has been sold, list it in the unsecured debt list category. Vehicle payments can only be affected by Chapter 13 or pass through as before if you're keeping the vehicle under Chapter 7 with a reaffirmation if the creditor wishes to let you keep paying. Most do, unless you have a bad payment record or have no insurance. No private service or credit counselor will deal with vehicle payment problems. That's a matter for your bankruptcy attorney. In Chapter 13, you may be able to pay all your debts for the same or a couple hundred more than your current vehicle payment. The 5th category is loans for personal property. Purchases of furniture, toys for big boys, boats, trailers, tools, rent-to-own, appliances, and other hard goods are secured debts. You must pay them or modify them in a Chapter 13 or negotiate a reaffirmation or surrender the goods in Chapter 7. List such debts in the personal property loan section on your creditor list and put the payment for each in your budget. 6th category is loans for money with a security interest in personal property where you didn't purchase anything at the time. These loans were not made for the actual purchase, but are usually for cash, putting up the property as collateral. They used to be common, but now few creditors make such loans. If you have one where you didn't make the loan to buy the goods, or you gave a list of household goods to get a cash loan, list this in this section. Only Chapter 7 or 13 can eliminate or modify this type of loan. The seventh category is co-signed loans. You may have co-signed for someone, or they may have co-signed for you. List all such loans in the co-signer section of the creditor list. If you are paying the loan, put the payment in your budget if you have not already done so. To pay or not to pay. If you default on a co-signed loan, the creditor can go after your co-signer. Your default affects their credit. So you'll want to pay such loans to protect your co-signer unless they file bankruptcy, or you want to let them pay it. However, if you co-sign for someone else's loan and they default, you're on the hook and have to deal with the creditor because of their default. So this is something to discuss with your bankruptcy attorney. Private services generally can't help you with this. The eighth category of debt is unsecured debts. Hospital and medical bills, most credit cards, cash advances, payday loans, NSF fees, parking tickets and tolls, criminal fines and restitution, repossession deficiencies, eviction costs. These are the most common. Many of these don't report to credit bureaus. Many sell these debts to third parties. You may have to work on this list later. It's probably the stuff isn't on your credit report. You will list them on your unsecured debt list with the address on the last two bills you received. If a collector is involved, you list both the original creditor, such as Glen Lake Hospital, with the address, and then you list the collector, Glen Lake Hospital, care of Acme Collection, 1 North LaSalle Street, etc. That way you don't duplicate the debt, but you know if there is a collector involved.